Hello. Today we're going to talk about the case of Performing Rights Society Limited versus Hickey. The content of this video is going to be as follows. First, we start with the facts of the case. Then, we're going to talk about the conceptual framework and problem. Then, we end up with reasoning and solution.
Let me begin with the facts of the case. So who are the parties? The Performing Rights Society is plaintiff and Hague is defendant. And what has happened in this case? Hague was the owner of the restaurant where he performed music to entertain and satisfy his guests. Performing Rights Society visited the Hage's restaurant and discovered that Hague was playing some of the music of society's copyrighted songs. A member wrote to Hague notifying him of the copyright and requesting a payment of royalties to Performing Rights Society. Including in that notification, Performing Rights Society testified that they wrote a suggestion to take out the society's license, which allows play the music freely. Hague was not aware of the possible copyright in music. For this reason, it thought that the letters just thought of ways to make money. Afterwards, Hague stopped playing the copyright music, but Performing Rights Society sued Hague, claiming that Hague deliberately refused to pay for the royalties. Though Hague replies that he was innocent of the broadcast of the record. So what court is handling in this case? The court was handling in this case was Zambia High Court at Lusaka. However, uh, the Zambian law was not used, since in the Zambian law there was no Copyright Act. Instead, they made use of the English Copyright Act of 1956.
The conceptual framework and problem. First, I would like to introduce an intellectual property. Intellectual property can be divided into two branches. One is artistic project property, and the other one is industrial property. In this case, it's about artistic property. Artistic properties are protected by copyrights and neighboring law and neighboring rights. When we look more into the depth of copyrights and neighboring rights, the owner of the copyright has no right to prevent others from using the idea and the knowledge. But the owner does have the right to restrict or prevent people from using the work itself. In this case, Hickey used songs during his show, and the Performing Rights Society is now going to court for the legal problem. So what is the main legal problem? The main legal problem is, was the copyright infringed? Is the defendant guilty? And should he pay for royalties and damages? What questions have to be answered by the court? Well, the four main questions that have to be answered by the court are: were the songs in questions performed without the permission of the copyright holder? Was the defendant aware of the copyright? Was the copyright infringed? And at last, are there any fees that have to be paid? What are the relevant laws and regulations, and what do they regulate? The first relevant law is the French law. French law is number 57 289, Article 27. United Kingdom copyright, Section 2, Part 5 and 3. The United States copyright 101 and 106, Part 4. All these three regulate the right of performance, which is the right of the author to communicate a copyrighted work to the public. Then we have the Copyright Chapter 701, Section 13, Part 3, which regulates a defense to infringement of copyrights. Then at least we have English Copyright Act Chapter 701, Section 7, Part 2, which regulates a defense to infringements of copyrights. What are the relevant theories and concepts? The first relevant concept is copyright, which is an incorporeal statutory right that gives the author of an artistic work for a limited period the privilege of making copies and publishing and selling them. The second one is a precautionary rights. That is the right to exploit a copyrighted work for economic gain. The last one is the right of performance. This is the right of the author, only the author, to communicate a copyrighted work to the public. So what is the relationship between the relevant laws and relevant theories? Well, it's pretty simple. The relevant theories are protected by the relevant laws mentioned above.
Lastly, we will be speaking about reasoning and solution. As for the plaintiff, they claim that they lost royalty fees by reason of the defendant not taking out the plaintiff's license to play the records. As for the defense, they claim that they were unaware that they were committing any copyright infringements. Based on the evidence, the judge ruled that the defendant was in fact unaware and had no reasonable grounds to suspect that copyright subsisted. Therefore, the plaintiff was not entitled to any damages. He also ruled that the plaintiff was entitled to the profits of the performance of April 26, 1976. This is because he did perform the three musical works without a license. The judge ruled that based on Section 13, Part 3, that at the time of the infringement, the defendant was not aware of any wrongdoing to which the section relates, and therefore the plaintiff was not entitled to any damages against the defendant. But the judge did rule against Teki on the matter of right of performance since he was publicly playing the copyrighted music. The plaintiff is hereby entitled to the profits of that particular day.
Thank you for listening to this video.